Good morning, everyone. Welcome to the session on arbitration and mediation today, here at the fourth edition of short-term course on legal aid and allied laws. Today, we have with us Mr. Akash Gupta as the resource person. Sir holds position as the assistant editor for the Indian Review of International Arbitration, peer review board member for the International Indian Arbitration Law Review, and advisory board member of RMNLU Law Review. Apart from his academic achievements, Sir has been appointed as an arbitrator and a conciliator in numerous commercial disputes, showcasing his expertise in the field. His contributions have garnered recognition, as he was awarded the prestigious Young ADR Academic of the Year award by the Asia Pacific Center for Arbitration and Mediation. Furthermore, he was awarded a full scholarship to attend the Paris Arbitration Academy. Sir has earned his LLM in International Commercial Arbitration Law from Stockholm University and has completed his BA LLB honors from TNNLU. Demonstrating his proficiency, Sir has conducted workshops and credit courses on various topics, including arbitration, mediation, negotiation, mooting, and ADR competitions at 30 different law schools. Notably, he has shared his expertise with prestigious institutions such as Stockholm University, the University of Bristol, CNLU, NUALS, and TNNLU. Sir has also volunteered as a judge for over 60 moots and ADR competitions, including renowned events like the WIS, JESUP, Stetson, and FTI. He is currently working as an assistant professor at Jindal Global Law School. Welcome, sir. We welcome you for the show.
Harsh, can you give me the share access?
Yes, sir. Please go ahead.
Thank you. Okay, just give me a moment. I need to share my screen. Sir Kalpesh sir for coming up with this idea of short course on legal aid, and thank you very much sir for this opportunity to share my insights on arbitration and mediation. We all look forward to your work sir, and thank you Harsh for this introduction. Okay, so before we start our discussion on arbitration and mediation in context of legal aid, the first thing which comes to my mind is that why Kalpesh sir has actually thought of including ADR as one of the topics in this legal aid course. So the first thing which comes to our mind is that why do we look for the non-traditional method of resolving dispute when it comes to legal aid? So the reason why the coordinator of this course has actually thought of ADR is because there are two ways of resolving disputes. The traditional method is, of course, that you go for litigation and you resolve the dispute. There are non-traditional methods, for example, ADR. To give you an insight into traditional and non-traditional method of dispute resolution, I'll give you a simple example because some of these students come from the law school. There are professionals also, so this example fits for everyone. So imagine that you stay in a law school hostel and there exists a dispute in between two parties. So how do you resolve that dispute? Do you actually directly take the dispute about your friend to the vice chancellor's office, or do you try something else? Now, taking your dispute to the vice chancellor's office is more like The traditional method of resolving disputes, that you go to the disciplinary committee or the vice chancellor. But that's not the only way to resolve your dispute. There are other ways to resolve your disputes. For example, is that one is that you talk to the person itself. Let's say A and B has a dispute. A and B sits together, try to find try to find a resolution. Second is that you involve. Let's say Harsh is your common friend. You ask Harsh to actually mediate it. To mediate your dispute. Let's say if Harsh is not able to facilitate the discussion and we are not able to reaching a solution, we nominate Kalpesh sir to be an arbitrator. So he decides that, Akash, you are right, or B, you are wrong. So an arbitrator is somebody who decides the dispute. An arbitrator does not only facilitate the discussion. Now, the reason is that when you go to the authorities, for example, when you move to the vice chancellor's office or in the disciplinary committee, there is a long set of procedures which needs to be followed, which will take some time. Similarly, in real life, imagine that if I come from a marginalized community of the society, and I have a dispute pending with, let's say, my landlord. I live on a place which is a disputed property. Let's say it's a government property, and I don't know about my rights. So somebody comes to me and say that, why don't you file a case against the government? That's one way of resolving disputes. But do you actually think that the government will not have a standing counsel to fight against you? So, in that particular situation, there can be some other ways to resolve the disputes. And that is something, why do we see ADR as one of the potential way of resolving dispute? Now, the reason why ADR is the future, or maybe we can say that ADR is actually the present now because a lot of people are opting for this. The reason is in India, the backlog of cases starting from the Supreme Court to the High Court and to the district courts, it's a lot. Currently, I think it's an old data now. It must have increased by now. So it's 4.3 crore cases the last time I checked. And why do we have a lot of backlog of cases? Because we have judicial intervention in ADR matters. So let's say that if Professor Kalpesh sits as an arbitrator, he decides that Akash, you are right, and Harsh, you are wrong. In this dispute, if I'm right, Harsh does not pay me. Harsh does not, allow me to stay on his part of the land. What happens? Harsh, like I have to go to the court to enforce the arbitral award rendered by the arbitrator, Professor Kalpesh. Now, the problem is sometimes the court also intervene in the arbitration award, in the decision making of the arbitrator. Now, all of these actually constitutes in a lot of delays, and therefore, it's also a negative point that even if it's ADR, there are certain room given to to the judiciary for intervention. However, the law for ADR, of course, provides that it has to be minimum. But at the end, at some point of time, it's the discretion of the judges. So that's another reason to it. The third one is that parties are not able to enforce the contract. Now, what happens is that, let's say, even if both the parties are ready to go for ADR, one of the party after winning it is not able to enforce the contract, enforce the arbitration award, or enforce the mediation settlement agreement. So if the parties are not able to enforce the outcome of that particular dispute, then what is the use of having this resolution system? So these problems actually indicate that, some of the reasons why people actually are willing to try out ADR than litigation, because litigation has its own time. You can't choose judges and it's already burdened with a lot of cases. Any questions so far in understanding the backlog of cases? Okay, so I don't see any questions, so let's go to the next point. Introduction to ADR and legal aid. Now, ADR is the wide concept which provides that this is an alternative to the dispute resolution system. In ADR, basically, there are two ways of resolving disputes: traditional and non traditional. Now, traditional is litigation, non traditional are all of this: arbitration, negotiation, mediation, lok adalat, there is early neutral valuation, emergency arbitration, all of this comes within this. Now, there is a division in between in within ADR itself. One is called adjudicatory, adversarial, and the other one is called non-adversarial or non-adjudicatory. Adjudicatory means that there is a person who has been given a task to decide that what are the rights of A, what are the rights of B. So there is a decision making involved. If you look at a trial or a litigation in court, it's an adjudicatory process that there is a judge who decides it. In the previous example, where I was discussing that in our dispute, mine and Harsh, Professor Kalpesh sits as an arbitrator. So Professor Kalpesh cannot say that why don't you guys discuss in yourself in an arbitration, because Professor Kalpesh has to actually decide that whether Akash is right or whether Harsh is right. When he decides this, that's what we call an adversarial or an adjudicatory method. However, let's say if we appoint Sir to become a mediator, what he will do, he'll try to facilitate the discussion that both of us are influenced, both of us are trying to go for a mutual solution. Now, that is the difference in between adjudicatory and non adjudicatory. In adjudicatory, in ADR, it's of course arbitration. In non adjudicatory, it's negotiation, mediation, conciliation, lok adalat. Now, let's spend some time in understanding these. Negotiation is a two parties process where two parties sit together and negotiate. There is no involvement of a third party. In mediation, it's an involvement of a third party. The third party facilitates the discussion, but the third party is not allowed to provide potential solutions. When the third party can also provide you potential solutions, that is called conciliation. So there is a very thin line of difference. It's more like an Asian difference in between mediation and conciliation. Before, one of the difference was before the enactment of 2023 Mediation Act, another difference was that in mediation, the mediation enforcement was not governed under the Indian laws. However, now, if you look at the Mediation Act 2023, it also provides for an enforcement mechanism, just like you have the conciliation enforcement under the Arbitration and Conciliation Act. Now, the last one is Lok Adalats. Now, Lok Adalat, we'll discuss this in terms of Legal Services Authority Act. Any questions so far in understanding ADR methods? Okay, if you guys have any question, you can write on the chat box and I'll try to come back to you. Okay, now let's understand that what exactly is legal aid. Now, a legal aid is more like an assistance of counsel or legal advocacy for people living at or near poverty in legal matters, okay, that fall outside, that falls within the marginalized community, marginalized society. So if let's say that there is a person A who has an ongoing dispute and who is not able to, represent themselves, or they have certain financial restraints, they're not able to fully represent themselves, then a legal counsel may provide legal aid. And this is something which is also provided under the Constitution of India. There is an act, National Legal Services Authority Act, which also provides that there is a obligation of the state to provide legal aid. Now, in terms of the disputes, there can be several sort of disputes. One is a commercial disputes, family disputes, disputes against the government. There can be criminal disputes also. But with respect to the legal aid part, it's the civil civil subject matters which are a part of this. So basically, legal aid is to provide help to the marginalized sections of the society in terms of providing them a legal assistance so that they can fight their case either in the court of law or with respect to any of the ADR methods. Now, the distinction from traditional litigation is something which I have already discussed, that there are certain problems associated with traditional litigation system. One is that time, it's a time taking process because you have backlog of cases and the judges are overburdened with cases. The judge's appointment also takes time. There are certain procedures which needs to be followed. There are very harsh and fast rule for procedures. So let's say if you have to submit a copy, you have to submit a document to the judge, you have to make sure that this copy is also given to the other party. Everything is governed by civil procedure code under the civil matters. However, if you look at the non-traditional methods like arbitration or mediation, I'm not saying that there is no procedure for that. However, the procedures are very flexible if you compare it with CPC. And it's mostly the arbitration centers which come up with these set of procedures, or the mediation centers which come up with these. So the idea is they make it flexible. Sorry. So the idea is that they make it flexible to attract the customers of ADR. That's the reason why there exists a difference in between the threshold of the requirement for procedural regularities. Another part is confidentiality. If you look at the traditional method of resolving dispute litigation, whatever happens in a court is a public forum. Anything which is decided by the courts, you can find it on the internet. If it's a reported judgment, you'll also find it in certain repository. However, whatever happens in ADR setup, mediation, conciliation, negotiation, arbitration, everything is confidential. Unless until the parties want to make it public, everything is confidential. So let's say it's a dispute in between a community residing in a slum area with a builder. Okay, this slum, of course, will have no problem in going to public at large about that particular dispute because they have a leverage over it. However, in that dispute, the builder will not be willing to go to the public at large that I'm fighting this dispute in between the slum, community and us. The problem is that particular community and the builder, if they decide to go for mediation, and somehow some of us actually represent the community which is actually residing at that particular part, at that piece of land, and they come up with a deal. Let's say that the builder constructs a fresh set of flats which will be given to individual families, and they'll vacate the land only on this condition, and there is a 6 months period given for this transition. Now, that if it's a mediation, everything remains confidential, the terms of this. So it's a win-win for both the community as well as the builder, because the builder doesn't want you to actually go to public and showcase that I'm using strong arm against this community which is residing at that land. For the land owners, for the land people who are actually residing on the land, for them, it's a good thing that they are getting a good deal. May not be sure if they go to the courts that they'll get a free flat for this. So in mediations, there may be a chance that some things which you get, some outcomes can be even beyond what you'll be able to achieve in the courts, because both the parties are going to extend the pie and get something out of it. So everything remains confidential, nothing is public unless until both the parties sign a clause which provides that this particular arbitration or mediation is, we are fine if this is put on the public website. I'll give you an example for this. For example, International Chamber of Commerce has an arbitration center. So what they do, their default rule is, in the ICC rules they provide, by default you agree to make the procedural award on the procedures public. So it's a default rule that parties themselves have, like, if you don't opt out of the system, it is already agreed that they'll make it public on their ICC repository. And they redact all the versions, the name of the parties, the amount in dispute, the country name. They just write claimant versus respondent, and they talk about only like the seat of arbitration was, let's say, India, and the issue was of jurisdiction of arbitral tribunal. So there are versions like this. However, in India, we don't see these kind of arbitral awards repository where you can actually find data about arbitral award or mediation award, so that you get some sense that how is it actually being conducted in India. In India, the Arbitration Council of India has a vision to do this, but still India is working on this. Okay, so now let's go to the next part, that what is the importance of ADR in legal aid? One is that its accessibility to justice. Sometimes when there exists a dispute and you try to fight against a party which has a good financial background, there may be a chance that they are going to use the strong arm in litigation, and they're going to stall the process for such a long time that by the time your case comes to your case comes at a hearing stage, you have already lost that particular place. So accessibility to justice will increase because at the end it's, you don't have to wait to get justice, and you can get it through different methods like mediation, and community mediations are taking place, family mediations are taking place, and now we also have a mediation act which regulates this whole regime of mediation. There is a set of requirements which is required for the mediation settlement agreement, that what are the things which needs to be there. Time efficiency, if we use ADR in legal aid to provide support to the marginalized sections, then it's, of course, it's quicker than the than litigation. Cost effectiveness, preservation of relationships, maybe a chance that you're not going to sour your relationship with the other party, because at the end you're deciding all of this in a confidential setup. Community empowerment, reduction of court backlog, tailored solutions, because the courts will have a limited set of solutions which are already provided, which are in accordance with the law, which are provided within the letters of the law. However, when you try out ADR, it can be a tailored solution for the parties at hand. So therefore, it can be one of the advantage for using ADR in legal aid. Confidentiality is something that which we have already discussed. Now, let's spend some time in understanding the legal framework for arbitration and mediation and then legal aid. For arbitration, the legal framework is Ancestral Model Law, International Commercial Arbitration 1985. So, this was more like a template law which was laid down by Ancestral, and Ancestral said that whatever countries want to adopt this, copy paste it in your national laws, you can. It's a template. So, this was the template of 1985. Then there is New York Convention 1958, which provided that if there exists an arbitration award which is rendered in Singapore, you can take that award directly to India and it can be enforced, because Singapore and India are both members of New York Convention. Finally, in 1996, India came up with Arbitration and Conciliation Act 1996, which actually adopted Ancestral Model Law 1985 and also adopted New York Convention 1958. So in India, if there is an arbitration award rendered from anywhere in the world, which is a member country of New York Convention, it will be directly recognized and enforced in arbitration in India by the help of Arbitration and Conciliation Act 1996. With respect to legal framework for mediation, so there is a 2019 convention that is called Singapore Convention, and the full name is United Nations Convention on International Settlement Agreements resulting from mediation. More popularly, it is called Singapore Convention 2019. Now, this 2019 convention actually provides that if there is a mediation settlement agreement in Singapore and India is also a member, you can take that mediation settlement agreement, come to India, and the Indian courts have to enforce that particular settlement agreement. Now, this is more like New York Convention of Mediation. Finally, in 2023, there is an enactment by the Indian Parliament, which is the Mediation Act 2023, which regulates the regime of Mediation Act, and it provides that mediation settlement agreements are enforceable in India. Previously, there was no regime to actually make it enforceable. So, how parties used to actually enforce it? By saying that it's more like a contract in between the parties. So, enforcing a contract is a longer process than enforcing an arbitral award or enforcing a mediation settlement agreement. Okay, now I see certain questions on the chat box, so I'll try to answer it now. As you said, rich might influence, which takes much time, the case to come before the bench. On the rich influence in area, I'll say if you look at this, that whether if the parties are from different background and they can influence the parties or the judges or the arbitrators, it's everywhere. Whatever process you do, it can be influenced. However, in terms of ADR, you have more control. I'll tell you how. So let's say if it goes to a judge, who appoints judges? It's the state which actually appoints the judges. Who appoints arbitrators? It's the parties who appoint arbitrators. When I say parties, it's not one party, it's both the parties who appoints the arbitrator. Usually when you appoint an arbitrator in a dispute like this, so let's say if I'm one party and B is another party, I appoint arbitrator X, B appoint arbitrator Y, and both the appointed arbitrator X and Y will appoint a third arbitrator, the presiding arbitrator, which is the Z arbitrator. So in that case, you can actually control the influence of one party by countering with the influence of other party, because both the parties have equal footing in deciding whether they want to go for arbitration or mediation, what is the seat for arbitration or mediation which they look for, what are the rules. Let's say if they say that whether they want to go for an Indian rule like IMC Hyderabad rules or MCIA Mumbai rules, or if they want to go for Singapore rules, SIAC rules or ICC rules. So it's the parties which has to actually choose. When I say parties, it's both the parties and not one party. However, in courts, of course, if you have a lot of influences to pull strings, of course you can. But the other party cannot do anything because everything is within the control of the judges, or let's say it's the senior advocates who will get the hearing first. So it's a lot of processes which is involved. But in ADR, it's of course it's within the party's control to do all of this. So I'll say still the better version is still ADR. There is a second question, which is in a dispute, if one party wants to come with ADR, on the other hand, one does not, then what will be the status? So ADR is ADR is only ADR mechanisms you can only enter with the consent of both the parties, unless until both the parties give an unequivocal intention to undergo ADR mechanisms. There cannot be any ADR mechanisms. I'll give you an example. In the example of hostile dispute in between me and Harsh, let's say that I want to go for mediation. However, Harsh is not a big supporter of ADR. Harsh says, no, I don't want to go to the mediation. I want to go to actually directly to disciplinary committee. I can't force him. It's on the consent of both the parties. The beauty of this is that imagine that there is a there is this land parcel dispute in between a builder and the community. The community, of course, wants to go for court also because they are not going to lose anything. It's just that the process will be long. However, the builder will never want to go to the court. The reason being because that will affect the brand value of that particular builder. But the builder cannot force the community to necessarily go for ADR unless until they give consent. And even if they give consent, they have a lot of control. Who will be the arbitrator? Who will be the mediator? Everything has to flow from both the parties. The beauty of this is that both the parties have to be on board. Let's say if there is only one arbitrator or one mediator which needs to be appointed. Let's say that there is no consensus on one name of mediator or arbitrator. The rich party cannot appoint it. One party cannot appoint it. You have to go to either an arbitration center or mediation center or the court itself. They'll nominate one person to act as an arbitrator or mediator. So this is how it is counted. It provides a balance in between both the parties. Okay, now there is another comment that court also sent to arbitration many times. I'm not sure if I understand your question, but I presume that your question is sometimes the court also sends certain matters for ADR. So now this is something which comes within the section 89 of CPC. Now that actually provides that, let's say if a dispute is filed, let's say this hostile dispute, let's say that Harsh goes to a district court, files this, and in that case the court says, come on, this is not a dispute fit for litigation, it's actually fit for ADR. So if there is an element of settlement of a dispute through ADR, the courts actually refer it to certain mechanisms which are provided under section 89 CPC. Some of them is of course mediation, lok adalat, arbitration, conciliation, or judicial settlements. Now, for please understand this, the court cannot send you without the consent of both the parties for arbitration and conciliation. For these two methods, the court will ask for your consent. Only if you consent, the court can refer. Even if they refer, you are not bound to go because there is a Supreme Court judgment, which is AFCON's case, which provides that you need to have the consent of both the parties. Okay, now there is another question for negotiation, any provision applicable. So there is no law for negotiation as such on an international level, also on a national level, because negotiation is the most wider in comparison to mediation or arbitration. There is no set of rules. I'll give you a reason, I'll give you an example to let you know why do we don't regulate this negotiation. a negotiation can, so basically a negotiation is so wide, so in between a dispute between me and Harsh, a hostile dispute, that is also negotiation. Let's say if it's about the land parcel example, that's also a negotiation. So how you regulate negotiation? The reason why it's not regulated, because you can do as you like, and it's upon the parties. Unless until both the parties actually agree to something, there is nothing which is binding. However, you are right in this, that if we don't have a provision, what happens to the enforceability? Because we don't have a law which actually provides that if two parties enter into a negotiation and we sign a negotiation settlement agreement, how do we enforce it? Let's say that we got a resolution in my favor, but Hirsch is not ready to follow that. So what do I do? Can I go to a court? Because if I go to a court, I have to showcase that this provision provides that this negotiation settlement agreement has to be enforced by the courts. For example, you have a Mediation Act or Arbitration Act, but there is none on this. So there exists a gap with respect to negotiation enforceability. Okay, so there is another question, that in mandatory mediation provisions, it forces parties to come to the table. Why so? Okay, so I think you are referring to the Commercial Courts Act, the provision which provides that if the dispute is within the bracket of this much, then you have to try out the mediation first. Only if you exhaust that mediation provision, only then you can move to the commercial courts. Now, those provisions are exceptions to the rule of consent, because the law itself provides a mechanism that you have to undergo mediation. Once the mediation fails, only then you can move to litigation. So you can, of course, call this as a multi-tier clause, which means that first you have to undergo mediation. Only if there is a failure of mediation, there is no settlement, only then you can move. And that is allowed by the courts in India as well as in the West, because the courts say that in order to reduce the backlog of cases, to make it more efficient, and to make sure, so basically this provision, mandatory mediation, is more like an extension to section 89 of CPC, because previously section 89 of CPC wasn't there. It came later on that we'll send it for ADR. Then there is a next stage, that there is certain mandatory mediations that we'll ask you to go for. However, there is no mandatory mediation in terms of all civil subject matters. There was a discussion for the Mediation Act 2023 for this, that whether we should make it all mandatory, and it was a part of the drafts. However, the final act does not have this mandatory mediation, which is the Italian model, in which all the disputes of civil nature have to necessarily go for mediation. So it's of course allowed. It's the parliament's mandate to do this, and the courts have actually approved this. Okay, so there is another question. What is the meaning of judicial settlement under Section 89 of CPC? So, judicial settlement is more like in front of the judge itself. If there is a settlement, if the parties come through a settlement and say that we have already resolved this, so what happens? The judge will actually copy paste the terms and conditions of the particular settlement and signs it. That is actually a judicial settlement. So the judge is also a part of that settlement. And because it's a judicial settlement, it has a high enforcing value, because the judge himself or herself signs it and copy paste all the terms and conditions. Okay, there is another question. If one of the party does not satisfy with the result of arbitrator, what happens? So in that case, there is a section 34, which provides a limited ground for challenging the award, which is, so there are grounds mentioned. Just a second. So under section 34, there are a list of grounds mentioned under which you can challenge the arbitral award, which provides for, let's say, that there was no jurisdiction of the arbitrator, the validity of arbitration agreement is in question, the arbitrator was biased. So these grounds are mentioned. Only on these grounds you can challenge the validity of you can challenge the arbitral award. You can't say that the arbitrator didn't decide this rightly, the arbitrator was wrong in decision making. That is not a ground for challenging the arbitral award. So it's a very limited ground on which you can challenge. If it's successful, it does not have the force of law. If it is not successful, then you have to follow it. So one shot is reserved with the courts to try out the validity of the arbitral award. So please don't think that once the arbitration has happened, there is an award. It has unlimited powers. It is actually limited by the court's intervention under Section 34. Okay, there is another question. Can parties be referred to ADR under Section 89 without their consent or only when one party consents? You can send to ADR mechanisms the parties without the consent of both the parties in terms of negotiation, mediation, all of this, lok adalats. But you cannot send it for conciliation or arbitration without the consent of both the parties. And this is not me saying this. This is the Supreme Court judgment, AFCON's case, which actually provides for this. Okay, now let's get back to the discussion of the legal framework. Let's touch upon the legal aid. So, Legal Services Authorities Act 1987 came into picture, which actually was done in order to achieve the dream of Constitution Article 39A, which provided for free legal aid to the poor and weaker sections of the society and ensure justice for all. Then there is Article 14 and 22, Clause 1 of the Constitution, which also makes it obligatory for the state to ensure equality before law and a legal system which promotes justice on the basis of equal opportunity to all. National Legal Services Authority has been constituted under the Legal Services Authority Act to monitor and evaluate the implementation of legal aid programs and to lay down policies and principles for making legal services available under the Act. Now, this NALSA has different bodies within it. There is a state level body, there is a district level body. Now, all of them actually conducts a lot of activities to empower the marginalized sections of the society, the people who are actually required for legal aid. So they actually regulate all of this, and they also conduct lok adalats at different levels, national level, state level, then district level. So in lok adalat, what they do, these authorities actually compile a set of cases which has an element of settlement, and they club it all together. They designate it for lok adalat. In the lok adalat, the parties actually go, and the of course the other side's counsels are also there. It's more like a very short negotiation. It's like they say that, are you ready to pay this much? If they say yes, the judge actually signs that. So there is a settlement, lok adalat settlement. So this is how it's happening, and lok adalats are not only happening physically in India now, it's also virtual. There is an ODR platform, Sama, which has done quite a lot of online lok adalats. So, and it has actually disposed of millions of cases with the online lok adalats because it's very easy to conduct. It's very easy to have large number of people to come up for the lok adalats, because for physical setups you need a lot of infrastructure, but for online it's much easier. So it's already happening, and NALSA is doing its bit for achieving the objectives of the Constitution of India 39A of providing free legal aid. And then we move to the next part, community mediation. So it is a form of ADR that focuses on resolving conflicts with a community through facilitated dialogue and negotiation. It's not formal, it's informal legal process. Community mediation is grounded in the principles of inclusivity, empowerment, and collaborative problem solving. And there have been success stories of community mediation. Now, let's understand the process of arbitration in a nutshell. That there are appointment of arbitrators. Once the arbitrators are appointed, then both the parties submit their memorandums. Once the memorandum is submitted, then you have the hearing process. After the hearing process and the evidence taking, there is an award, and the award can also be challenged and it can be enforced if the parties themselves do not pay the amount. All of this is coming from one thing, which is arbitration agreement. Unless until the parties actually have an arbitration agreement, the consent to arbitrate, then this process cannot see the light of the day. Then there is a mediation process. In mediation, there can be, please understand this, that arbitration or mediation or any ADR method can be done through two ways. One is ad hoc, one is institutional. When I say ad hoc is simple, that let's say that in a dispute in between me and Harsh, we decide to have Professor Kalpesh as our mediator. So there is no rules as such which is applicable because it's ad hoc. There is no institution which is going to administer the case or facilitate it for booking our Zoom calls or for booking a physical venue. But let's say if we go to IMC Hyderabad or MCIU Mumbai, so they have an institutional setup to facilitate all of our mediation or arbitration. So they'll do our booking, they'll make sure that what are the timelines, what are the rules for arbitration mediation. So ad hoc and institutional are two different things. It happens both in mediation as well as arbitration. Now the mediation process is, first is that you need to have a mediation clause. Second, that you need to appoint a mediator. The mediator cannot influence the decision making of the parties because it's only a facilitator role. It's all a voluntary process. The parties can leave anytime. Confidentiality is a cornerstone of mediation process. If the parties do not settle anything, it is totally fine to leave the discussion. If they settle, there needs to be a settlement in writing so that the parties later on cannot change their stance. Whatever the parties decide here is actually going to be binding upon both the parties. Okay, let's talk about the challenges in ADR with special context to legal aid. Now, of course, ADR is a potential option, potential solution to disputes resolving, marginalized sections of the society. But there are certain challenges to it. One of the challenges is the lack of trust. Imagine that there is a dispute in between a community and the builder. And let's say if you go and tell them that, if you try out mediation or arbitration, then there may be a chance that if you do mediation that you'll get whatever you want. But the problem is they'll not be connecting to your idea of mediation settlement agreement because they think anything flowing from the court, anything flowing from the judge has more value than a mediation settlement agreement. So they don't trust anything apart from the courts. So that's one of the biggest challenge. Second is lack of awareness, which is actually connected to trust, because there is no awareness that there exists something called mediation settlement agreement that is also enforceable, that is deemed to be a decree of the civil court. This non-awareness actually amounts to lack of trust. Then there is enforcement issues. Sometimes when you try to enforce it, the judiciary may stall the enforcement by saying that there is certain procedural irregularity and previously there was no enforcement for mediation, but of course it was there for conciliation. So those issues also act as a roadblock. Perceived bias. Some people have a perceived bias that, if it's court, it's enforceable. If it's not a court, it's, the other party can be biased. Or for example, the question on the rich background, people can influence the court, so of course they can also influence. So those perceived bias, that particular question actually raises a threat, because the question is also applicable in terms of a dispute in between the community and the builder, because the community will have a perceived bias that this is something new, so maybe they'll influence it. So that question stands valid, that how do we actually counter this perceived bias of the parties? So that is of course a challenge in area. Now, how do we overcome these challenges? One is a public awareness campaigns, that there needs to be certain more involvement of these stakeholders. When I say stakeholders, it's everyone. It's the community, which is actually the community of people who require legal aid. Then it comes with the legal professionals who are actually doing, who are acting as a legal aid professionals. Then lawyers, judges, and different stakeholders who are entering into contracts or interacting with these communities. So public awareness and training is important. Legislative reforms, there can be special provisions with respect to ADR in context of legal aid. There can be certain amendments which can be made to regulate, to recognize and provide a faster enforcement mechanism, so that it will attract, it will be a very attractive opportunity for the people to choose ADR instead of traditional methods of dispute resolution. Now let's look at future trends in India. So online dispute resolution is already happening in India. We have a lot of platform, Resolve 360, Sama Center for Online Resolution of Dispute, which are actually doing this. So of course, it's happening also in the context of legal aid. There are online local adalats which are being conducted, and it's quite successful. Hybrid ADR hearings. Nowadays, hybrid ADR hearings are quite normal. Even we see this in the Indian courts. International collaboration in ADR, it centers in ADR. We have a lot of arbitration mediation centers in India, and a lot of this is also upcoming. Then there is something called blockchain arbitration. So blockchain arbitration, one of the example is Kleros. So where what happens, everything, all the contracts are in a form of smart contracts, and people don't know exactly the name of the person who is going to arbitrate, but it's more like they have an IP address, or it's more like, it's blockchain, like 1011 something like this. So the dispute, the moment you have a dispute, it directly goes to arbitrator. You don't know the name of the arbitrator, but they decide your dispute, and that happens very quickly. So the time which they take is way lesser than online dispute resolution or your physical arbitration or mediation. Now, role of legal aid professionals. So, training and certification is, of course, what that the lawyer should be trained with respect to legal aid, and how do you actually, assist the marginalized sections of the society, integrating ADR into legal aid services. That how do you actually maximize the resolution process or help these communities, supporting vulnerable populations. About this, I was writing about one of the paper on legal aid, and I came to know that the Bar Council of India rules does not provide you to do a pro bono service mandatorily. Of course, it actually, it it uh, it does not put some mandate that you have to do it, but it of course say that if you do it, it's good. But there is no mandate to do it. But when you look at the Bar Council rules from US, in US there is a mandatory requirement to do pro bono service, to provide free legal aid, and there is a requirement. So for example, it's 50 hours of free legal aid that you have to do, and unless until you do this, and it depends on different state bar councils in US, unless until you provide a certification of this, your license for the next year or for the next term will not be renewed. So in India there is no rule which actually mandates it. It's just that they say that if you do it, it's very good, but there is no mandate. But there are certain bar council rules, especially in US, which actually mandates you to do it. Now the question is, if it's not a mandate, then how many of us are actually going to do it? Okay. And the question is, if there is a mandate, then there is no question that how many of us will do it, because everyone has to do it, because there will be no renewal of licenses. Now, this is something which is a very different concept, and I was talking about this to some of the professors also in India, and a lot of people said that it will take some time to mandate these legal aid or pro bono services as a mandatory requirement to renew your license. And also in US there are certain bar council rules where they provide that before you become a full-time advocate, there is more like a bar school in which you have to actually act as a pro bono associate. So there are rules like this which are already happening in the West, but in India it's not a mandate. There is no rule which asks you to do it. If you do it, it's very good. Okay. And that's it from my side. Thank you, but I'm looking forward to the questions which you may have. Okay, so I see a lot of questions, so I'll try to answer one by one. Okay, so I left with the ADR question on section 89. The next question is, can compoundable criminal cases be referred to Lok Adalat? For Lok Adalat, it's not allowed, criminal compoundable cases. However, there are cases in which the compoundable criminal cases mediation has happened, and the court has actually approved of this mediation under the inherent powers of the court, and there were quite a successful mediation in these cases. So I'll say lok adalats no, but mediations in certain cases, the courts, just a second. So the courts have actually the court has actually approved of mediations in criminal cases. So do I have time to answer the questions?
Yes, yes, yes.
Okay, sure.
We have more time. The participant, you can unmute and ask. Sorry, I have there's a power
No
disconnected,
worries.
power alive
No worries.
Spain.
No worries. No
I
worries.
have joined
I'll
from
take the
side.
questions.
Just participant, you can raise your hand. Hers, please unmute them if you don't want to speak, or you can drop a question in the chat box.
Sure, sir. Okay, so the next question is how does Mediation Act affect on ADR mechanism as a whole? What are the changes that occurred in mediation after the enacted Mediation Act? So I'll say the one of the positive change of the Mediation Act is that it provides a enforcement mechanism with respect to the new enactment. The changes that occurred in mediation, there is no change as such that how you conduct mediations. It's just that now mediation is going to be regulated because there are certain standards which are required by the act. There is no rule as of now for the mediation accreditation. For that, there is a Mediation Council of India which is yet to be set up, that is provided under the act. So the accreditation which keeps on happening in India, you must have seen that there is a this mediation training, there is that mediation training. The Mediation Council of India will regulate all of this, that what are actually recognized by the government of India. If it is not recognized, if you do it, you will not be impaneled on any of the mediation centers which is approved by the government of India. So these are some of the bigger changes, but one of the thing which should have been taken is the international mediation settlement agreements coming from outside India, whether that is enforceable in India, like New York Convention analogy, that is not something which is addressed in the Mediation Act. I'll still say overall it's a great step that now you have an enforceability mechanism. You have actually tried to set up Mediation Council of India. A Mediation Council of India, when it's set up, it's going to make a lot of changes, and then this whole market of mediation will be disrupted because everyone is doing whatever they can. However, whatever they like, they're doing it. But once Mediation Council of India frames rule on accreditation, who can be a mediator, what are the qualities, everything will be regulated by them because that is their power, which is given by the Mediation Act. The next question is there any recent case law which talks about the arbitration clause is correct, but the service agreement is void or voidable? Please enlighten us. Yes, there are a lot of cases, and this is not recent. Like are a set of judgments in which the contract validity was in question, and this is something what we call doctrine of separability. That the contract was invalid, however, the arbitration agreements remains valid. This comes from doctrine of separability, which means that if there is an attack on the validity of the contract, it does not mean that it's also an attack to the validity of the arbitration clause. An arbitration clause is separable from the main contract. Okay, so of course that is fine. If you want a case law, please write to me on LinkedIn. I'll send you the link. There are a lot of landmark judgments coming from UK, which are also referred by the Indian Supreme Court. There are new judgments also. Next, there is a question: if a dispute is in between two companies situated in UK and India, where will ADR happen? If one of the countries is chosen, will there be a difference in laws? Does it mean that once a country signs international declaration, then laws have uniform provisions in signatory countries? So in arbitration or mediation, it's parties' agreement, which is of paramount importance. You can choose, for example, in this dispute, India and UK company, they can choose to apply Singaporean contract law. They can choose to apply Swiss Arbitration Act. They can also choose to apply Swedish Arbitration Act to be applicable to the arbitration agreement. In arbitration, it's party autonomy. So there is no question of which laws can be applicable. Whatever parties decide, that will be applicable. You can also choose an international law on contracts, that is CISG, the Convention on International Sale of Goods. You can also choose that. So you are free to choose any law. There is no problem with that. Okay. Then moving to the next question, sometimes officer in charge of the police station solve many problems in marginalized area, like police called, both parties gave some outfit on that, like do they do things settle this there. Will it be fruitful for both of you? What it can be called, sir? Any views on this? So there are a lot of trainings happening with police officers with respect to mediations. So basically, when you look at these examples where the police, you complain to police, the police calls the other party, and the first stage, what they try to do, unless until it's something like a heinous crime, they try to actually settle in between yourself. That is actually mediation. The problem is the police officers or the police personals are not always trained with this. So some of them are doing very nicely, smoothly, but some of them are actually aggravating the dispute. That's the reason why I see a lot of my colleagues are giving trainings to police officers, to these departments for mediations. Also, this is not happening only in a physical setup. This is also happening now on phone calls. There are, on phone calls there is a complaint, then police calls you on phone call where it's not very easy to meet physically. So this is also happening virtually through the phone calls. So of course it's mediation, but that is something which is way different from a mediation happening within an institutional center, because that is something which is more like the police officer, the government authorities itself acting as a mediator. Okay, but that's actually a very good way of resolving a lot of disputes, because instead of going into courts, these are actually resolved. So a great job by these officers. The next question is whether assisting marginalized and vulnerable communities is responsibility of government or NGO only. Why no one talks about advocates in their own capacity can also assist the poor? Why is an institutional channel necessary for assisting downtrodden communities? Ideally, it's, of course, it's also, it's responsibility of all of us. Of course, it's the larger part on the government also, because the constitution provides this, and that's the reason why we have nulsa in place. However, it's of course with the NGOs for us to do our bit. Talking about the capacity of the advocates, it should be ideally, for example, I was talking about the advocates renewal license under the bar council rules of US states, that you need to do certain pro bono services, only then you are eligible to get a renewal. But in India, there is no rule as such, and there may be a chance that it will come in the near future. But there is no mandate to act as an individual person to do pro bono. However, there are certain law firms in India which does this, and which also publicize this, that we have done these many cases on pro bono basis. The big firms, of course, take some of the pro bono services, but it's not all the firms which are doing this. Some big firms are doing this. They also, brand it or package it well, but it's not that all the firms are doing it. So if the big firms are not doing it, expecting that individual advocates should do, it's a very big debate. And this is a good topic for a panel discussion, keeping with a law professor, two people from the lawyer practice, and two people from the law firm practice, and maybe one judge. But I'll say that if I have to give my personal opinion, I think it's better to put a mandate to do certain pro bono services, which will actually help in providing certain legal help to marginalized sections of the society. Another question is, do we have an arbitration council in India? The act, of course, provides that we need to have arbitration council of India, but it's in the process. It hasn't actually laid down their own rules and everything, but the act already provides for this. So in some time, we'll see an arbitration council of India, which will regulate the whole regime of arbitration in India, including the arbitrators' qualification, arbitration program accreditations, all of this. Limitation Act applies to ADR proceedings. So the Limitation Act is a act which provides in general about limitation. ADR Arbitration Act is a special act. So the special act will overrule this Limitation Act. So the time limit which is provided under the arbitration clause has more weight than the Limitation Act. This is something which is laid down by the Indian courts. The next, okay, so I think we are already over time. If you have any questions, I'm just writing my email ID. You can just connect to me, or you can connect to me on LinkedIn, and we'll get back to you. Yeah. Thank you very much.
Thank you, sir. Thank you so much for an informative session. I'm sure the audience found it really informative. Now I invite Dr. Kaushik Bagchi, the faculty convener of Center for Legal Aid Program in USRL Ranchi, for the vote of thanks.
Good morning, all. And first of all, I thank Dr. Akash Gupta, for giving such a nice lecture and enlightening us regarding the concepts of arbitration and mediation. Specifically, I liked very much the segment of mediation, because I think everyone has gone through the processes of arbitration. They have been taken into consideration, but mediation and conciliation are the aspects which are least taken into consideration, either in classroom teaching or in practical relevancy. They are treated as least importance. So thank you very much for dealing the aspects of mediation in such a detailed manner. However, I think there are still certain lacunas while taking into consideration the aspect of mediation, because there are certain enactments where there are provisions for mediation, but huge amount of fees is claimed for going through that particular mediation process. So once the party feels that once I go for spending in the mediation process, and if it is it's not coming to a particular resultant, then again we have to return back to the court. So why to invest in mediation? So that is also, I think, one of the lacunas. For example, in Commercial Courts Act, I think we have given this particular provision, and the charge of mediation is excessively high. So these things are very much becoming very much of relevancy and importance under the current all of the NUSRL Ranchi, as well as all the participants, and the co-convener of CLAP, and the student co-convener of CLAP, and Kalpesh sir, primarily, because he is responsible for bringing all these new ideas within our young brains among our students, and encouraging them to do legal aid in a proper manner. Thank you, everyone.
Thank you very much, Kaushik sir, Akash, for your valuable time. So look forward to you in future events also. Thank you.
Thank you so much, Bhakti sir. Thank you so much, Kalpesh sir. Thank you so much, Harsh. And thank you so much,
Thank you.
participants.
Thank you, sir. Thank you for joining. With this, we wind up the first session for today. We'll start the next session in 5 minutes. Thank you for joining, everyone.